All right, so let's start this again. Good afternoon, and thank you for joining our Century webinar. I have Jane Flaherty with me today. Jane is a local estate planning attorney, and I know through the financial planning process, I have a lot of conversations about estate planning. It's a big part of financial planning to make sure that people's assets are going to flow in the most appropriate fashion for what they want to happen. And estate planning is a big deal. So if you're a client of mine, you know that we talk about it a lot. So I thought today we would bring Jane in, have an expert here to talk a little bit about estate planning and some documents. And I have a list of questions and we'll just talk and see how things go. So we'll go from there.
All right, let's
Welcome.
do it. Thank you.
So first, I thought we would start when people think of estate planning, the documents that are discussed in estate planning. I'm sure people think of wills, number one.
Mhm.
I know there's more and we'll talk about more,
Mhm.
but let's start with the most basic of a will.
Mhm.
Who needs a will and why?
So most people think everyone needs a will, and I would agree, except for I don't think unless you're over maybe age 28 or come from a lot of wealth that you need a will. And so, but most people I would recommend needing a will.
Okay, 28. Why at that age? What's that?
Well, I do packages for families where kids are graduating high school and going to college, because the second they turn 18, the law says they're grown-ups.
Right.
And so my poor children, happy birthday, honey, sign here, sign here, sign here. But they have no money. The only thing they're living off of is what I'm doing. They may have a car, they may have a few other things, and later on we can talk about titling assets. But right now they haven't accumulated anything necessarily to have a will. But if you have a child, you need a will. Under that age. If you've accumulated wealth, you need a will under that age.
Sure. Okay. Or have a car, have a home, things like that. Okay. All right. So the other documents, which are always about part of the packet that I talk about when I recommend somebody to an estate planning attorney, besides the wills, is the powers of attorney, the HIPAA authorizations. Can you talk a little bit about those, what they are and why they're important?
Just the healthcare powers? All the powers?
Yeah.
Okay. Sure. So a power of attorney is a legal document where you give someone else the right to do something for you. And there's different purposes for those powers. One of the powers is to make healthcare decisions for you. That's a healthcare power of attorney. It's only valid when you can't make your own decisions. And so you want to have that in place, because if you're ill and you can't make your own decisions and no one has that authority, your loved ones have to go to probate court and get a guardianship appointed so they can make decisions for you. So a healthcare power is really important. The HIPAA waiver I use separately than a healthcare power, because I have a large family, for instance, and if I was in the hospital, my two sisters would knock the doors down to find out what's going on with me. But I don't want them making decisions for me. So I do a separate HIPAA waiver with more people on it, so they're able to talk to doctors and get answers, but they're not in my healthcare decision-making power.
So the HIPAA waiver is saying, doctor, you can give information to these people.
It's communication, right? It's a 96 federal statute. It's valid all through the United States. And that's allowing them to talk. And I updated my HIPAA waivers to make sure we included via Skype and Zoom and all the lovely coded things, telephone, whatever. So that's HIPAA, healthcare. And then if you are in a position in your health where there is no chance of recovery, let's say you're on machines and two doctors say your loved one is permanently unconscious or terminally ill, you can decide while you're well whether you want all the plugs pulled and let God see what God has to say about it, right? They will never remove comfort care. That's called a living will because it's valid when you're alive. And in that one, your loved one, your agent, is not the one pulling the plug or not pulling the plug. They're enforcing what you wanted. So if you did not want the plug pulled, they enforce that. If you do want it pulled, they enforce that. And it gives them the legal right to have that standing. So those are powers of attorney that have to do with healthcare. The power of attorney that has to do with finances is very powerful. And Janice, you know this one really well because you have to deal with this all the time. And how people, what it says, what it allows them to do. And so health powers of attorney for finances, I make mine durable, which means they're valid now while you're valid, and they're valid when you're not valid. And a durable financial power is the second document that keeps you out of guardianship in probate court. So the durable power is basically a guardian of the estate for the finances, and a healthcare power is the guardian of the estate for decisions about your body. And those are very important.
Good, okay. The durable power of attorney, as soon as you pass away, it's gone, correct?
All of them.
Right, all of those are gone. So, you know, if you name somebody as your durable power of attorney and you think that they can make medical or financial decisions for you after your death, that's not the case. Okay, so just make sure people are aware of that. Okay, good. Let's go back to the will. What if somebody dies in the state of Ohio who does have assets and they don't have a will and they don't have their beneficiary designation set up or titling, which we'll talk about in a little bit? What happens in the state of Ohio?
Right, so that's called an administration. So in the state of Ohio, we have 88 counties. And depending on where you lived is the county in which you will have a probate. And probate means to prove. So your loved one would take your death certificate and some paperwork to the probate court, or use an attorney to do it, and get appointed by the court to administer that estate. And that appointment by the court is like a financial power of attorney, but after you die. So you have to get court authority to get the bank account or sell the car or talk to the employer.
Got it. Okay. So what about for a business owner? I just met with a business owner this morning. Is there anything different they should think about when they're thinking about putting wills, powers of attorney and things in place? Is there anything different a business owner should keep on top of mind?
You know, I'm going to answer the business owner thing in a second because I wanted to go back to the will part. If you don't have a will, it's an administration. But not having a will, all the states have decided where your assets will go if you don't have a will. And the basic idea is it first goes to your spouse. And if they're not alive, it goes to your children. And if you don't have any, it goes up to your parents. And if they're not alive, it goes to your siblings and their kids. The rules are different if you're a blended family. And we know how many blended families there are. And when they blend early, they think all their kids are their kids. But the surviving spouse's share is cut down if they're not the parent of the children. And so there's a lot of tweaking you want to do on that. And so not having a will, your assets will be distributed, but they may not go to the people you want. And Janice and I have talked about this a lot, your blood relatives versus your chosen family and where you want things to go. And so it's called intestate succession. It means you don't have a will and the statute, the law tells you how your money goes. So sorry, I wanted to say that with dying without a will.
Good.
Okay, and then business owners. So this is something that I love when a business owner works so hard and they get their business down and they have their operating agreement and they know what's happening and they know exactly what's going on, what happens when they die, where their shares go, who can buy them, all the stuff. They bought insurance to pay it out, everything. But you just need to take that thought process and move it to your personal life, right? So you've taken care of your business, especially when you, I mean, running a business is like having a baby. I mean, it's your kid, right? We both know this. And so we make sure that we protect ourselves and our clients if something happens to us, but we need to take that thought process to our lives. And so they're really parallel practices.
Good. Okay. So you mentioned blended families. Let's jump to that because that is a big deal. And I know you and I have talked about it quite a bit. So like you said, there are a lot of blended families. So we get a husband and wife that come in to do a financial plan. And here I find out that second marriage is for both. They each have children that came into the marriage and they want to plan for each other and make sure that their finances are in place. And that's terrific. The estate planning can get really complicated there, right? The gentleman, again, I met with this morning, he said he has 4 daughters. And then later, the more we talked, 3 of the daughters were his biological daughters. The third was from his current wife's first marriage, but it's my daughter and I take care of her. Okay, that's great. Let's talk, let's talk a little bit about estate planning and what you may need to do. So talk a little bit about that as far as, not number one, making sure that the people you want to inherit, whether they're blood relative or not, and number 2, making sure money doesn't get into that no good ex-husband's hands, right?
Yeah, I just had that discussion with clients yesterday. because they have funds that they're going to have go to his children and some funds they want to go to her children because it had to do with the right thing to do from the prior marriages. And they just want to make sure those particular assets go to the right place. And so we were talking about how to title it because and then all the other assets would be divided equally among the 4 kids. So then we talked about, that's terrific, but do you want to do it per stirpes or per capita?
Mhm.
And so if it's per stirpes, it means that if someone predeceases you, their children would get it. It would go down the line of the bloodline.
Per stirpes is a Latin term that means like that it follows the bloodline, if you will.
Yeah. And so if the one child has no siblings, and so if that child had predeceased, then the money that child would have gotten in per stirpes would go to the ex-wife.
Mhm.
So what we did was we took all of the children and we did it per capita, which means you need to be alive in order to inherit. And so if all 4 of them were alive, each would get 25%. But if 3 of them were alive, each would get 33%.
So that deceased child's family, if they have children, wouldn't inherit his or her part.
Right, at this time.
Right.
Right,
In per capita.
Right, and
Okay.
you know, it just like financial planning, right? You should, once you get set, you should at least check it quarterly,
Mhm.
right? And with estate planning, I tell people, check it every 3 to 5 years, unless you have a change in age with kids, someone is born, someone has died, there's a marriage, you've moved, there's a job change. Those bigger things
Mhm.
could affect how your estate plan is, just like your financial plan.
Right. Okay, so we talked a little bit about that, the whole ex-wife thing. I think we're good on the blended family. I mean, I just think it's,
You want to talk about blended families that don't get along,
sure.
where they don't get along? I mean, that was just inheriting money.
Right.
And they wanted the money to stay with the kids. But when you have a blended family that does not get along, they like the terrible divorces, fighting, issues like that. They don't even want the other spouse a guardian if the
Mhm.
child, that kind of thing. Some spouses don't get guardianship. And so you really have to figure out how to take care of this money for these people, these kids. And so I'm not a big person to promote trusts, but there's some reasons that I would have trusts. And I might have it for that kind of a blended family.
Mhm.
I also use some language and talk to people about custodial accounts, which talk a lot about, and you make sure you know who you have as a custodian and who you choose after that. But when you have a family that does not get along, or there are relatives who will stick their nose in a lot,
Mhm.
there's a few other ways to make it more bulletproof.
Okay. And the trust document then will allow people to make sure that the assets pass to the most appropriate place, make sure it doesn't get into the wrong hands in that trust document. So good reasons for trust documents for certain reasons.
Mhm.
I get it. I'm not a
Mhm.
big proponent of trust unless there's certain reasons for it.
Right.
Right.
You and I agree on that. And so let's just do an example. So let's say parents have an agreement to share the cost of the child's upbringing. And one parent dies early and has a trust. Well, the other parent wants all the money from the trust to pay for it. So in your trust, you could have an agreement that you have to look at the budget, or you have to have an agreement on what's paid and what's not paid,
Mhm.
or an agreement to make sure you see what funds were given and how they were applied. Like if we gave them X dollars for this family vacation or whatever, was it used on a family vacation, or did he or she get a new car? Right. So
Mhm.
there's ways to put in checks and balances.
Got it. And is the court overseeing that?
No, hopefully not.
Right.
So hopefully not. So a trust, when I was a young lawyer, most of the trusts were testamentary, which means they were created in your will. Well, when your will only matters to the probate court. So if your trust is created from your will, it stays in the probate court and you have to report to the probate court.
Mhm.
And everyone has to have notice by the probate court. And so there are still many testamentary trusts being monitored there. I have one that was started in the 60s that I'm working on.
Mhm.
And so I do current trusts that are revocable trusts, which means you can change them.
Mhm.
And then when the people pass, the testators pass, it's an irrevocable trust, but it has all its terms. The trustees you chose should monitor it. You can also choose a trust protector to monitor it. You can put in the safeguards you think you need to have on there. If there was a fight, let's say the beneficiary is in that age of life where they're like, I observe everything.
Right.
And they don't like that the trustee is saying no. They could go to court and ask the court to interpret the document.
Got it. Okay. So while we're on trust and who may need them or what may be a good reason for them, what about special needs? Obviously, people that have special needs kids.
Oh yeah, that's a number one trust. You've got to have a trust for that. And the reason you have to have a trust for that is when you have a child who gets aid from the government, if they get, after they're 18, if they get assets in their own name, it messes up their benefits. And so there are multiple ways to do things. I mean, you can have an ABLE account with the state of Ohio, which is great, but all the money in that would end up going back to the state of Ohio when the special needs person passes. And so many times you do a special needs trust, which puts money aside for the special needs person so that they can get a computer, go on a vacation, do all the things that Medicaid does not cover. And when they pass, if there are any funds left, it goes to the family. Right. Or someone else, does not go to the state. And so that's a really important thing. And many people think they put in a special needs trust, but you really need the right language to make sure that the assets are sheltered. Because if you were Medicaid, wouldn't you come back and say, nope, you owe me all this money?
Oh, absolutely. Yeah.
So we got to make sure that you have language on there so they can't get that.
So Medicaid can't come back. Okay. Okay. The other issue that comes up with family discussions and reasons for trust is maybe they clients have a child that has a drug addiction or a gambling problem or something like that. And that can also be a good reason for a trust. Thinking about, if you do have somebody like that you love in your life, would you really want to drop money into their lap? Because that can really push them over the edge in all sorts of ways. So a trust can also help protect that person from themselves.
Right. When I left, I was a trust officer at National City and Key. And one of my last accounts before I left there and opened my own practice had language in the trust that I actually had to have the beneficiary drug tested before I could distribute any funds.
Wow.
I'm like, I'm not the parent. But that's what that was.
Sure.
Drug tested.
Sure.
And now it's very different because that was 20 years ago. So
right,
yeah.
Right. Okay. But those are good reasons for it. So okay.
Plus spendthrifts. So
It's spendthrifts. Yeah. Yeah. Same idea. Okay. Anything else that you can think of as far as I think
well, obviously
needs.
So mental health is not always a special need, but there are times there, depending on mental health, medicine is so good now that people who have mental health issues can be fine if they're on their meds. But if they get off their meds, there could be issues. And so if it's that severe in your life, you should think about that. Obviously the spendthrift, if they have undue influence, especially younger people or a personality that would be influenced by a boyfriend or something like that, you might want to do that to make sure, obviously Medicaid and special needs. What else would I do it? Yeah.
Okay. All right, good. Thank you. So let's move on to divorcees. I work with several divorcees. What should they think about differently when it comes to estate planning? I know when I work with a divorcee or one is referred to me, maybe from a local divorce attorney, sometimes it takes a long time for that person to even reach out to me because they're exhausted. A divorce is an exhausting process. Can you talk a little bit to that? Is it, about what is the need of a divorcee as far as changing their documents?
Right. And one of the, I don't know if it's a cool thing about you, but one of the things is, I don't know if you know this, Janice worked as a paralegal in a divorce office for years. So she has heard and seen a lot of it, right?
Yep.
And unfortunately, she sees the part while they're in the midst of it. And it's so exhausting that one of the things that bothers me about some domestic relations attorneys, they're really tired too. And unless you have a good paralegal who is going and making sure, oh, the house went to them in the divorce decree, let's retitle it. Oh, you were supposed to change your life insurance. Oh, you're supposed to get a life insurance. So you have to look at the divorce decree and see what it says and see what happens if it was implemented. Because I have cases in probate where somebody died, the spouse should have the house, but the divorce decree from 25 years ago, they never changed the title. So we have to go back and we have to try to fix things that weren't done 20 years ago. And if you're divorced, have Janice look at the title to every asset you have and make sure that it's right. So anyone who is divorced, if they did their estate plan before, they usually have their spouse named to make medical decisions for you and financial decisions. And if you just went through a divorce that wasn't so pleasant, do you still want that person to be the one to make medical decisions for your financial decisions? And another part about that is if you happen to have a really good divorce, because there are some good divorces and you want to make sure a spouse gets this or a spouse gets that. And if that's true, you can still name them as a beneficiary or a person able to make decisions for you, but you have to have it dated after the date of the divorce decree for it to be valid.
Right.
So, but on retirement plans, the date of the divorce decree, the spouse will be deemed predeceased, which brings up titling and secondary beneficiaries. But on divorce like that, there's other issues, of course, because it's never that clean. It's not just money, it's emotions and kids and who gets what and what family. And so there's a lot to discuss there.
There is. There's a lot to discuss and a lot to change to make sure, again, that things are happening in the right way. All right, so you mentioned account titling. Let's kind of move to that, which is a big thing that I talk about with financial planning, is to make sure that your certain accounts that can be titled jointly, or that you can add a transfer on death designation to do that, or to make sure that there's beneficiary designations designated in the most appropriate fashion. It's a big deal.
It's such a big deal. It's such a big deal. I have this handout I send to my clients or people who call me, and it says the power in titling your assets. This is where all the power is. And one of my favorite things about COVID, which is a really weird thing to say, but people are in their homes and they have the time to look at their assets. And so talking to people, I'm like, go to that file cabinet or that pile that's 6 feet high and just start looking at it, you know, or when the mail comes in again. Because right now, if you have, when we were kids, we were never told how to title our assets. You open up your first bank account and you put it in your name, you know, and 40 years later, you're like, what? I have to do something. So the rule is, if the asset can be titled, you can control where it goes and stay out of probate court. Right?
Right.
So the number one thing I do with married couples is they both think they own the house. Oftentimes they think they both own the house because both names are on the mortgage. The mortgage is a liability. The house is an asset. You guys have Janice, you know this. But the names on the mortgage have nothing to do with the ownership in the house. So clients yesterday, she says, no, I have a joint tenants with rights of survivorship on the house. I said, no, you don't. You have both of your names, it says husband and wife. That means one of you passes, half of that house goes through probate. And probate, for instance, in Cackowski County and most places, an attorney will make 4% on the first 100,000. So let's just say it's because for math, I'm not the math number person. Let's say the house is 200,000. So $100,000 asset is going to go through probate court, and that's $4,000. And I could just do a deed for you for under $300,
right? To get it. To get it fixed before.
So no pain in the butt, no worries about that, you know, no taxes, no creditor issues, none of that with probate. So that's a house that's usually people's biggest assets. Married couples, if all the cars are in one person's name and that person passes. The state of Ohio, this is one of the big treats about being married. In the state of Ohio, you can go to the BMV when your spouse passes with the death certificate, and you can get all the cars in your name. The only limit is the value of those cars cannot exceed $65,000. So if you have cars that add up to more than that, you would take the car that's of the highest value and you'd go to the BMV and you either put it in your name jointly or you put a transfer on death deed on that car. And then that car would go to your spouse or whomever you wanted at your passing, not go to probate. And the hard part for me is talking to people about when you're a survivor, a surviving spouse, because now you have to put a transfer on death or that car goes to probate. And the interesting part, people say, well, I don't know who's going to want my car. I don't know if I'm going to own this car.
Yeah.
Well, the transfer on death would be void if you sold the car or didn't own it when you died. But if you don't have it on there and you pass, whoever has to handle your estate, they've got to go to the probate court just to get that car released. So sometimes it's nicer just to pick one of your kids or your friend and give them the car. Then they can get it in their name and they can donate it, they can sell it, they can do whatever you want with it without much of a pain. So that's a house and a car. So bank accounts, if it's only in your name, it goes to probate court.
Yep.
So banks, brokerages, we'll talk about next, because I really nudge my clients, and I know you do, for primary and secondary beneficiaries. And so you own it. You don't want anyone else to own it right now, just you. But at the moment of your passing, you don't want it to go to probate, and you want someone else to have the right to get that money. And so then you put on a primary beneficiary. If you're married, it may or may not be your spouse. And then if you're in a die simultaneously, maybe you want it to be your kids equally, one kid, your sister, your brother, your parents, whomever you want, but that secondary beneficiary. And back to trusts, if you have a trust, you can make your trust the secondary beneficiary. And so that avoids probate. I'm on there. And that's the same thing with brokerage accounts. If a brokerage account has both names on it, it's jointly held. But if it has one name on it, only one person owns it, and you need to have a transfer on death on there. So we talked about real estate, banks, brokerage, motor vehicles. And so now let's talk about retirement.
Retirement accounts. Yeah.
Right.
So brokerage accounts are more the taxable accounts. When we talk about retirement, we're talking about IRAs, 401ks, pension plans, profit sharing plans.
SEPs, inherited IRAs, Roths, there's 403Bs. I don't know all these words, but they're tax advantaged. They're the things that you work your whole life to build up, to save some taxes and have things to retire with. And on those, when you're married couples have a benefit, another married couple benefit. This is federal, not just state. So this one is, if we're married and I pass and you're my beneficiary, well, I'm not taking anything out of my IRA right now because I'm just too young. And so you wouldn't have to take any out either. And you could wait until you're 72 and a half and take it out. But if you're my sister and you're my beneficiary, you have to take it out over a 10-year period. That's called the Secure Act. So basically, if your beneficiary is not a spouse, whoever's receiving it has to pay the tax on it over a 10-year period. And that Secure Act, I think, is a huge boon to tax accountants and financial planners.
Yeah. It's a huge boon to the IRS. It's a huge boon to, because they're the ones who they want to get the taxes soon and upfront, and that's why they put that in place. That law changed for anybody who passed after January 1st or January 1st, 2020 and after. Anybody who passed away before that, people can still stretch those IRAs over their lifetime. So it depends on the date of death for that situation, but it really can complicate things for the beneficiaries. There's a lot more planning now involved on the tax side that maybe you do some converting of IRA dollars to Roth dollars that can pass tax-free, or things like that, so that it helps your money that's going to be spent after you die to pay the taxes. It's going to be your money, not the kids' money or whoever you leave the money to. But to try to make that planning up front. So there's a lot of complicated stuff going on there.
But that's what the financial planner helps with. And if you have to pay the tax on it anyway and you're young enough, the thing I love my clients to do, if they could, is they have to take it out and pay the tax anyway. So then that's a conversion, which doesn't have limitations on it for an addition to your Roth. So, right.
But you can't do conversion of that kind of money. You can't do conversion of the IRA.
Right.
So you can take that money out of the IRA, pay the tax. That money can now go into a brokerage account and get invested, but it cannot go into a Roth.
Right, but if you do that, you can, but you have the income level.
Yes, you can only if you have earned income can you contribute money to a Roth. So it gets complicated, as you can see. And sometimes we have conversations where we're like, I forgot about that. Because the laws change constantly, as we know, and it's complicated. So sometimes we have, as professionals, we even have to take a breath, take a step back, call my colleague and say, okay, remind me what's going on here. So imagine what it's like for the person who's not a financial or an estate planning expert. So back to the IRAs, retirement plans, as far as, let me check the time, make sure we're still on. We're good. So the IRAs, 401ks, when you're naming beneficiaries, of those type of accounts, a lot of times it's best to name human beings and not trusts in those type of accounts. There are circumstances where the trust should be named.
Mhm.
But most times you want to think about that because the tax consequence of moving IRA dollars into a
Mhm.
trust, the trust is taxed at a much higher rate
Mhm.
than individuals.
Mhm.
So there's times where we need to be careful with that.
Mhm.
And that's something that we talk about when we're aligning beneficiaries with clients.
Right, it's true. And the hard part is some people, their largest, especially doctors, their largest assets are retirement plans.
Mhm.
And depending on their beneficiaries, and this is where your tax accountant and your financial planner and your lawyer really help, because if they're charitably inclined, you want to make all your charitable donations out of your IRA. If you have to start withdrawals on your IRA and you're paying income on it and you still have really high income, then you're going to want to give that money right to charity because then you don't get taxed on it. And so there are ways to play with things on that. Now, if you have no charitable intent and you just have lots of money and you don't want anyone to waste it because you didn't spend it and you want it saved and you worked hard to save this money.
Mhm.
Well, if it goes into a trust, it still has to be distributed, the income over that 10 years. But the trustee can take that income and distribute it out to hopefully multiple beneficiaries that are at a lower tax rate. And they can even deem that income to them. And then they're investing the rest of it. So it's now growth on it. So hopefully there'll still be a corpus of money to invest after they've taken and paid all that income tax on it.
Mhm.
But you need some advisors on that.
You need some tax advisors for sure, financial planners that do tax planning. There's a lot going on there for
Yeah.
sure.
Yeah.
Okay, so let's go back to the basic estate planning and wills, powers of attorney, things like that you're drafting for clients. What is that process like? That's all right.
Show
But
and
just,
tell.
yeah, just show and tell. Or just if a client wanted to go see an estate planning attorney, what can they expect as far as what kind of information, what's a
Yeah.
process feel like, what
Yeah.
time, things like that.
So I can tell you what to expect from me and my backup attorneys and a few other friends, but I can't tell you in some other places. So I'm licensed 32 years. I've been doing my own practice 7 years, and I'm very, very practical. So I like to listen and ask questions, like you figuring out that all those children were not his children, but you don't figure that out until you've listened to everything, right? And so listening is the biggest key. And my first question often is, what's keeping you up at night? What's bothering you? And we'll talk about it. But COVID, let me tell you, my COVID procedure, I had created all these fillable forms. I would email them to you or mail them to you if you're not an email person. And you would fill them out and you could email them back or take a copy and send it back to me. And then I create some draft documents. And I send you these I'll call you if I have questions first, and we'll talk through those. Then I'll create you some draft documents, and I'll send you only the parts I want you to read, because the rest of them it's a lot of language, and I don't want to get you to freeze because it's overwhelming. So I only send you the part I want you to see then. And then we talk about that. So if you say, oh, now that I see it in writing, I really meant to do this, or I meant to do that, and we chat about it. And then I create the final documents and you come in and you sign. Well, when you come in to execute the documents, we go through absolutely everything. And then you're signing things that you may not have read the whole thing of or understood. And so I give my clients 30 days to call me for any changes. And I do it for 2 reasons. One, I really want you to understand your documents, but 2, it's your estate plan. And if you don't, if day 31, you'd have to pay me again. So maybe it will make you read it because I want you to read your own plan, right?
And understand it.
Right.
Yeah.
But and I didn't bring my binder with me, but also what I do in part of my process is in my binder that I make for you, I have banks, tabs in the back, banks and brokerage and insurance, all kinds of insurance, homeowners, medical insurance, life insurance, all your motor vehicles, all your real estate, employee benefits, business interests, if you have your own business, your operating agreement, so we know what's going to happen. And basically on that, I ask you to gather those things. Where, as you can tell here from our titling issue, I spend a great deal of time walking clients through their assets. And so if you have bank accounts, if both of you or you passed the day before yesterday, and today your loved one is saying, I don't know what bank accounts he or she had, they would go to this binder and they'd see, oh, there's something from Key and something from PNC, and oh, there's an account that's online somewhere, and here's a credit union. So you've just saved them hours and days of just finding that. And so I call them breadcrumbs. And so you're just leaving them breadcrumbs, just a bit of evidence of what you have. And then you do the same thing for brokerage. And then many people, I ask them to please put in, we do a list of important contacts. Now, these may be your family members, but the important contacts you're going to need if something happens to you is your insurance person, your financial planner, your lawyer, your tax accountant, the people who mind your cat or dog, you know, the children's nannies. I mean, your parents, any of those important people who are on your team. And so if you provide that information, that is the greatest gift to your loved ones when something happens. But what's really great is it's actually a great gift to you, because you can also look at it and go, wow, I never really had it all in the same place. Like what Janice has you do is you end up seeing all of your stuff on one page, and it has to be a remarkable thing if you're not one of those people who are great with numbers and Excel spreadsheets. So that's my procedure. And then I show them all, I educate them all on all of it. And then they take the binder with them, and I ask them, and mine, I have a whole list of to-dos. And so I have a to-do list for the binder, and then I leave a next steps or what you should consider in it, and it goes with them in the binder. But one of the keys is I ask you to scan your documents, and you can give them to me and I'll save them in my cloud, but upload them for you. But more importantly, share them with your agent. So the persons you name to make healthcare decisions for you, they're not going to know where your binder is. But if you scan it and send it to them and it says my healthcare power, it's on their phone. When they get to the hospital, they've got their phone. But help them out a little more. Scan those documents and upload it to my chart. Upload it to Follow My Health, whatever you have there, and you've got it. I don't suggest a financial power is scanned and shared, because it is, well, I clerked for the judges of the probate court, and I still remember my judge, and he said, more damage has been done with a durable financial power of attorney than a loaded, well, he called it a Saturday night special, which is a loaded gun.
Yeah, they're really powerful.
They're
powerful
very
documents.
powerful, especially when written right.
Yeah.
And then your will. So I put in my binder a cover letter that you can say, this is a copy of my will. My original is wherever. And me, I just fold mine up and it's in a fireproof safe under my desk. But there are ways to get a copy of a will admitted to court. So you don't have to worry about that. But
It's got to make sure you change it if you update your will.
Right.
So yeah,
Oh, definitely.
yeah, there's a lot.
Right.
You just got to think about that stuff. But I like to make sure your agents or your executors or whoever it is that you name know where this stuff is or know how to get it, because that's the biggest issue.
It is. And one of the things that I suggest to some of my clients is they'll say to me, oh, I really need this for my parents, but they won't talk to me, or my kids won't do this, or whatever. And I say, well, if you've named them, not whoever you've named in your healthcare power to make a decision for you, it's the best time to say, I've named you. Have you named me? Or who's named in your healthcare power? And that's where a HIPAA waiver comes in too, because if you care about them enough and they may care about you, you could say, well, you're in my HIPAA waiver, so you can talk to doctors. Can I talk to your doctors? And it might open the door, because sometimes children lead the way, even if those children are 40, 50, or 60, they can lead the way.
It can be a really difficult conversation for some people. They have trouble talking about death or thinking about their impending death. And I have had clients in the past where we would start to talk about estate planning and honestly could break down and just not even have a conversation about it. So if you can and plan well, you're only doing yourself and your beneficiaries a big favor. I think we're pretty close to done with conversations. I'm going to go to the computer and check to see if any questions came in, and excuse me, I don't see any chats or questions. So last minute thing.
Yeah.
So one thing I do want to ask, one client of mine a while ago asked me, so instead of naming, he wanted to leave money to a bunch of charities. Okay. So rather than naming 7, 8, 9 charities that he really liked today on his IRA beneficiary form or whatever, I'm just going to name my brother as the beneficiary, and my brother will give all that money away for me. So, and luckily, I think I talked that person out of it. Talk a little bit about that on the state side. I'll talk about it on the financial side.
Sure. So I have actually had this more than I'd like to say. So first, there's two sides of it. One, it's wonderful if you trust your brother that much. It really is. But the moment you die, if you have him as your beneficiary, he gets everything. Once he owns it, it's like any gift. Once he owns it, it's his to do with what he wants. So he doesn't necessarily have to give it to those charities. That's number one. Number two, if it's probate and goes to all your brother, he's executor, and it says go to charities, then you can ensure it goes to charities if you don't want to do beneficiary designations. But here's the downside of that. With charities, it's not so bad, but I have a client who decided his other kids can't deal with this stuff. I'm just going to have one daughter. I want this one daughter getting everything. I want her getting the house and the cars, and I want her getting my bank accounts. And then when she gets them all, I want her to handle it and then divide it up among the kids. That is not a gift.
That's not a gift at all.
That is not a gift.
Right.
And we talked through that with the daughter. And I said, do you know the work you're going to have to do if you want to do this? And I said, it's legally yours.
And the tax consequence. Not to even talk about the tax consequence to that daughter.
That's the big issue. And so we talked about what the value of his estate was. So for an example, if the value of his estate after expenses or whatever is $100,000 and there's 4 kids, each kid gets $25,000. So this daughter who inherited needs to keep track so she can prove to them what it was. And then she has to write checks for $25,000 to each of her siblings. Well, she can't do that in 1 year unless she's married, because right now the amount you can give as a gift is $16,000. So if she writes a check for $25,000, she's got to claim, what's the math, $9,000 gift to all of these siblings.
She can do it. And she's not going to pay tax on those gifts, but she's got to file a gift tax return that needs to stay on her tax return for the rest of her life. So it's just administratively kind of a mess.
It is.
So
it's not a gift.
It's not a gift,
It's
especially
not a
if that $100,000 inheritance is an IRA. Because now this daughter now has to claim that $100,000 as income to her if she cashes it in to give her $25,000 to each of her siblings. So it's not a gift to do that.
Yeah.
So.
But that one we've done the math on before.
We have.
Yeah.
You've done the math on. I'm going to scoot up closer to the computer. My eyesight isn't that good because we have a couple questions. So, hi, Jeff. Are there any taxable assets that cannot be titled TOD? Not that I know of. You should be able to add a transfer on death designation to all bank accounts, all brokerage accounts.
Right. Anything you can title.
Right.
There's some issues with transfer on death, though. The people you're transferring it to must be alive. So you can't say to my son and his kids, if he doesn't survive me, you have to have names on it. But Jeff, if you have a certain asset, please put it in the chat so I know. What's the next one?
The next one, how do you fire a probate attorney? Say you're fired.
Yeah.
No.
That's really.
Let me go back to the.
A home. Absolutely.
Yeah,
I do that.
home.
I do that all the time.
Yeah, you can have that. So, but the TOD, let's go back to that for a second. I have had people with Vanguard brokerage accounts. For some reason, Vanguard does not allow a transfer on death designation to be named on a brokerage account. I think that's only on the retail side. I still haven't figured it all out, but I've had, so there might be some companies or some banks or custodians that don't allow the transfer on death designation. So, you know, if you need help with that, I can help with that.
I actually had that issue with one of the big firms when I talk about financial powers. So if I did a financial power and we made sure everything was fine for you, I asked my clients to give it to their financial planners and their banks while they're alive and while they're competent, so that if they become incompetent, the banks have already sent it through their legal department or you've already seen it. And many financial planners either accept it or they have them sign an affidavit saying, I want you to agree to this financial power, not the big firms.
Right.
Morgan Stanley won't. Merrill Lynch will not, Fidelity will, you have to use their particular form.
Absolutely.
So that means in the binder, under your financial powers, you would have a form, you'd have additional things under your brokerage because the regular financial power won't do that.
Absolutely. Got to use their forms for sure. One more, if you forgot about a bank account and fail to have a beneficiary, can you put it in your will? Anything without a beneficiary listed goes to my spouse. So if you forgot about a bank account and you failed to have a beneficiary, can you put it in your will? Sure. Basically, your will is going to say anything that I don't have titled,
Right.
here's where it goes. Everything left can go to spouse or whatever.
So whoever wrote this really seems to
That's a
have,
guy, yes.
right, has the exact key here. So your will, and once you're over 28 or start having any kind of assets like that, I always recommend a will. And it's for this exact purpose, because when you work with either one of us and you have everything titled,
Mhm.
and the will is a safety net. So let's say you forgot the one bank account. So instead of your, $500,000 estate going through probate, only one little bank account is going through probate. So there are different procedures you can use in probate. It's a full administration, a release from administration, different things. This would be a faster, quicker release.
Mhm.
Now your will, first off, does something really important, and it's almost the cost of drafting the will, which is waives bond.
Yeah.
So make sure your will says no bond is required of my executor, because that's usually, it costs some money and you got to pay it out of pocket first. And so the will is basically, think of it as a safety net for people who have all their assets titled properly. But if you have minor children, that's where you name your guardians. So you really need to have that one updated.
Mhm. For sure. All right, one last question, Jeff. How is a non-designated tax-deferred account distributed? So non-designated, I'm assuming you're meaning no beneficiary designation on that. A tax-deferred, an IRA, yes, okay. He's quick on the draw. The tax-deferred account distributed, it's going to be distributed according to your will. So it's going to go to probate, and probate's going to look at your will and say, so your IRA, you've got an IRA, you don't have a designated beneficiary.
Right.
Who does it go to? Yes, it goes through probate court, and the
Right.
will decides.
But
Or if you
but
intestate.
many times you lose the status of the IRA.
Oh, yeah, you could lose the tax. Yeah, you
Right, so
could.
tax will be due all at once. So you spend so much time putting money away for a Roth and an IRA and everything else. Please look at your beneficiaries on there,
Mhm.
please.
Yeah. Okay.
Please. And the last question about somebody wanting to get rid of a probate attorney.
Oh,
you
yeah,
may-
sorry.
You may need to just call me on that and we'll chat about it. And it also really depends on what county that person is in,
And depending on the court and where it's filed.
depending on where
Okay.
the court is. And there's a
Okay.
lot, people think probate's the same, but there is an awful lot of strategy in probate court.
So I'm in Lake County, Jane's office is in Cuyahoga County, and being in the divorce paralegal that I was for years, I know there's a huge difference between the courts in Lake and Geauga and Cuyahoga, I'm sorry,
Mhm,
as far as how they're handled. So I'm sure
mhm.
the probate's the same way.
Well, I love Cuyahoga County only because after you open the estate, everything's online. Lake County still has to have everything, but they are so kind and helpful. So Lake County is a beautiful county to be in,
Mhm.
and Cuyahoga,
But they just don't want it on paper.
right, right.
Okay, okay.
Mhm.
All right, well, we are at 12:48. We said 50 minutes. Look
I
at
know,
that.
look at
Look at us. So thank you so much for joining. Thank you for asking questions. Estate planning is a little piece of financial planning, but as you heard today, it's a big little piece. There's a lot
Mhm.
to deal with, a lot to think about, a lot to talk about.
Mhm.
Financial planning encompasses more than this, but it really is an integral part and something that I always talk with clients about. And again, Jane's one of my resources, and
Mhm.
glad to have her here with me today to share her
Right,
expertise.
and for all of you on, having a Janice, or if you have a different financial planner, is any professional, please make sure they talk to your accountant, they talk to your insurance person. We are your team. You are paying us money to take care of you. And I know certain things, and you could give me permission, and Janice and I could talk and we could walk through certain things to take care of you. So if you have a team together, please introduce them or use them. If you don't like them, get someone new.
Mhm.
Me personally, my children are older now, and years ago I switched to all providers that my kids would get along with.
Good thinking.
So,
All right. Well,
yeah.
thank you all for joining. I did record the session, so I will send it out to everybody if you happen to join late, but thank you, and we will see you soon. Take care.
Bye.